Losing a partner is a profound grief that reshapes everything, whether that loss occurred just 3 weeks ago or 3 decades ago. If you are a widow or a widower, there is a critical piece of information that rarely gets shared. Every choice you have made regarding Social Security survivor benefits, or every choice you are currently preparing to make, establishes a lifelong financial benchmark, and a vast majority of individuals inadvertently stumble on at least one aspect of this process. It is vital to examine 10 precise errors that surviving spouses frequently commit when dealing with Social Security, alongside 3 unpublicized strategic adjustments and the exact measures required to rectify your situation starting this very month. Some of these pitfalls are only relevant during the immediate months following a spouse's passing, while others quietly drain your monthly income indefinitely, regardless of how much time has marched on. Reviewing all of these options thoroughly is essential, particularly because the final strategic adjustment has managed to restore thousands of dollars to grieving spouses who had absolutely no inkling they were eligible for it. The regulations governing Social Security survivor benefits are among the most convoluted aspects of the entire federal infrastructure, and subtle annual adjustments mean that the guidelines in place when you originally filed might look entirely different today. Keeping a close eye on these shifts is the best way to safeguard your financial security. If you or someone you know has been navigating these complex waters, sharing this information could help them spot a costly error before it is too late. To understand the real-world impact of these bureaucratic traps, consider the experience of an individual named Walter. At 71 years old, Walter lives just outside Spokane, Washington, having dedicated 34 years of his life to working as a freight dispatcher for a regional transportation firm. His wife, Carol, served as a school librarian for nearly the same duration, and the couple shared 38 years of marriage before a cardiac condition claimed her life when Walter was 61. In the raw weeks following her memorial service, a supportive neighbor drove Walter to the regional Social Security branch because he felt far too shaken to operate a vehicle himself. Sitting across from a claims representative, he provided their marriage license and Carol's certificate of death. The official informed him that he was eligible to commence receiving survivor payments anchored to Carol's employment history immediately. After calculating the figures on her monitor, the employee state the monthly sum, and Walter signed the forms that very afternoon, relieved to cross one daunting task off his list during the most painful chapter of his life. For 10 consecutive years, he drew that precise survivor payout, which increased slightly each year with standard cost of living updates, never once questioning the arrangement. Why would he have any reason to doubt it? However, a few months ago, while sitting in a local cafe, Walter caught a conversation between 2 men at an adjacent table discussing a mechanism known as a restricted application. One man described transitioning from a survivor payout to his personal retirement benefit upon reaching age 70, while the other brought up delayed retirement credits, a concept Walter had never encountered. Returning home that afternoon, he logged onto the internet to establish a personal Social Security portal for the first time and reviewed his own historical earnings record, only to find a shocking reality. His independent career history as a freight dispatcher qualified him for a monthly sum that significantly outpaced the survivor benefits he had accepted since age 61, provided he made the transition now at age 71, with a decade's worth of untouched delayed retirement credits. Throughout that entire 10-year period, neither the original representative, the initial forms, nor any subsequent government correspondence ever indicated that making such a pivot was a possibility. Walter did not display negligence. He simply represents millions of surviving spouses who are left completely in the dark regarding the complete scope of their entitlements. Unpacking why Walter was left uninformed requires a closer look at a regulation that applies uniquely to survivor payouts, an attribute that is seldom clarified effectively, regardless of whether your claim was submitted this morning or 15 years ago. Standard retirement payouts generally bind you to a specific path once you file, but survivor benefits operate on 2 parallel, independent tracks simultaneously. One track is anchored to your personal career earnings, while the alternate track is built upon the earnings of your deceased partner. the Social Security Administration will exclusively distribute whichever amount is greater at any specific juncture. But a unique provision alters the landscape entirely. Widows and widowers possess the right to submit a restricted application to draw from just one of these funding pools initially, preserving the option to transition to the alternate pool at a later date. This specific operational flexibility is exclusively reserved for survivors and is completely unavailable for spousal benefits claimed between two living partners. No other segment of the Social Security framework permits this maneuver, and under current statutes, this privilege carries no expiration date. Recognizing this fundamental framework helps illuminate the 10 widespread errors, identifying which ones are unchangeable elements of the past and which ones remain active opportunities for correction today. The first error centers on the assumption that survivor benefits trigger automatically upon a spouse's passing. This issue is primarily relevant during the immediate aftermath of a loss, meaning those whose spouses passed away years ago do not need to worry about this specific detail, though it remains vital information if you are currently guiding a loved one through recent bereavement, even if your deceased partner was already actively drawing retirement checks, or if you were previously receiving a spousal allocation while they were alive. The survivor benefit demands a wholly separate petition and will not convert on its own. It is incumbent upon you to contact the agency by phone or visit a local office to formally initiate the request. The second error involves rushing to claim the survivor benefit at exactly age 60 without first evaluating it against your independent retirement projection. This oversight continues to siphon money away from individuals month after month, echoing the exact dilemma Walter faced. Electing to draw survivor benefits at age 60 rather than waiting for full retirement age triggers a permanent reduction of approximately 29%, because survivor allocations do not accumulate delayed retirement credits beyond full retirement age in the manner an independent retirement account does. On a base benefit designed to yield $3,200 every month, making this premature claim can permanently cost a survivor $912 each month for the duration of their life. This is far from an isolated forfeiture. It multiplies month after month and year after year across decades of retirement. The third error is one that a vast majority of people remain entirely oblivious to, which is failing to recognize that you can utilize one benefit source now and transition to the alternate option later down the road. This opportunity remains completely viable no matter how much time has passed since your bereavement. You retain the right to collect a survivor benefit today and pivot to your personal retirement benefit down the line, assuming you have left your own account untouched. Furthermore, even after an initial filing, surviving partners frequently maintain windows of opportunity to adjust their distribution approach outside standard timelines, utilizing built-in mechanisms designed to rectify missteps under numerous scenarios. If your independent employment record is poised to yield a higher monthly sum once you factor in the delayed retirement credits gained by waiting until age 70, you might be leaving that enhanced wealth entirely dormant while accepting a lower survivor check year after year, mimicking Walter's silent decade of financial loss. Moving to the fourth error, many families mistakenly contact their banking institution before notifying the Social Security Administration following a death. This is an early-stage misstep, but families have noted that alerting the bank first often prompts an immediate freeze on the account until Social Security provides verification, initiating a bureaucratic loop that can obstruct access to necessary funds for an additional week. The proper sequence is to contact the Social Security Administration first, secure validation that the passing has been officially recorded, and then present that verification to your financial institution. The fifth error involves spending any government deposits that arrive in the bank account following the date of death. While this is also an immediate post-loss issue, it is highly relevant if you are currently managing an estate or assisting someone who is. The Social Security Administration will automatically reclaim the payment distributed for the month in which the death occurred as soon as they are notified, irrespective of the specific calendar day the individual passed away. If an automated deposit occurs after a beneficiary has died because the agency was not updated immediately, those funds must be returned. A payment allocated for the month prior to the passing is typically still owed to an eligible surviving spouse, though it requires a distinct application process, meaning the funds are not inherently forfeited, but the distinction must be clear before any money is directed toward memorial costs or other liabilities. The sixth error is letting the deadline pass on the $255 lump sum death benefit. To speak with absolute candor so as not to waste your time, this specific payment must be formally requested within 2 years from the exact date of death. If your loss transpired more than 2 years ago and this funds went uncollected, that $255 is almost certainly forfeited, and attempting to pursue it is no longer productive. However, if your bereavement occurred within the past 2 years and you have not yet applied for it, making that phone call today is highly advisable. The seventh error is entering into a new marriage prior to reaching age 60 without first evaluating the statutory impacts. This regulation remains globally relevant regardless of when your prior partner passed away because it triggers the exact moment you remarry, whether that milestone occurs next year or 2 decades from now. Getting remarried before hitting age 60 can completely invalidate your eligibility to claim survivor benefits anchored to your late partner's earnings history. Conversely, entering a new marriage after celebrating your 60th birthday has absolutely no negative impact on that specific eligibility. This particular rule catches countless men and women off guard, primarily because it rarely enters conversation until after the wedding vows are exchanged, leaving individuals with no choice but to absorb the financial consequences. The eighth error involves disregarding the government earnings test if you continue to work while simultaneously drawing survivor benefits before reaching your full retirement age. This factor remains permanently active for anyone maintaining employment, no matter how many years have passed since their spouse's death. For the year 2026, the Social Security Administration withholds $1 in benefit distributions for every $2 earned above the threshold of $24,480 if you remain below full retirement age for the entirety of the calendar year. This earnings ceiling scales up dramatically to $65,160 during the specific calendar year you touch full retirement age. The encouraging element that is rarely highlighted clearly is that while ignoring this framework can cause a temporary reduction in your immediate checks, those withheld funds are not permanently confiscated. Instead, they are credited back into your monthly distributions once you attain full retirement age. It certainly feels like a punitive financial penalty when the money is withheld, but it functions much more like a temporary suspension than an absolute loss. The ninth error is failing to map out the tax liabilities tied to survivor income, an obligation that returns every single year for as long as you receive the monthly checks. Survivor payouts are subject to federal taxation based on your combined income, a calculation that aggregates half of your annual Social Security benefits alongside all other sources of taxable income. If this combined economic figure scales past $25,000 for an individual filing solo or surpasses $32,000 for couples filing a joint tax return, up to 85% of the Social Security benefit can be categorized as taxable income. A significant number of widows and widowers face an unexpected tax bill every single spring because of this reality, often repeating the mistake for years on end simply because no one took the time to explain the math to them at the start. The 10th error, which completely reframes every other issue discussed, is accepting the initial declaration from a Social Security staff member as the absolute and definitive truth. The personnel operating within these regional branches are not acting maliciously, nor are they trying to deceive you. They are providing technically precise responses to the exact questions you pose, but they do not operate as holistic financial advisors, and they are under no structural obligation to volunteer every single advanced claiming strategy available to your household. Consider the case of a widow named Diane, who was informed at age 60 that she could claim $1,767 a month in survivor benefits. At age 62, agency records showed she could draw either $1,791 based on her personal career history or $2,025 via her survivor track, and she was counseled to defer filing until age 66 to capture the maximum survivor amount of $2,706. Every single piece of data provided to her was factual. What the agency completely omitted was that Diane had the right to claim the survivor benefit at age 62 and subsequently transition to her personal retirement benefit at age 70, a maneuver that would have elevated her monthly checks to $3,674. Missing out on that insight cost her roughly $200,000 across her retirement years. The figures were accurate, but the strategic guidance was dangerously incomplete. Beyond incomplete advice, outright administrative processing errors can also disrupt your financial security. A woman named Linda, currently in her late 60s and residing in a rural community outside Des Moines, had been receiving a survivor payout based on her late husband's employment record for nearly 9 years when a routine federal audit flagged her account. A formal review by the Federal Inspector General revealed that systemic underpayments predominantly impacted widows and widowers whose partners passed away before reaching age 62, as well as survivors whose files demanded manual data entry where mathematical miscalculations were far more prevalent. The investigation estimated that nearly 40% of the surviving partners audited during that operational window were negatively impacted by comparable administrative blunders. Linda's husband had passed away at age 58 before ever submitting a personal retirement claim, which placed her file squarely within that high-risk manual processing category. Once the government bureaucracy finally instituted the correction, her ongoing monthly checks increased permanently, and she was issued a substantial retroactive lump sum check to compensate for the years of underpayments. Linda did not initiate that mistake. She simply operated under the assumption that the figures printed on her government statements were infallible, just like most citizens do. It is worth pausing on this reality because if you are reflecting on this and assuming that a 15-year gap since your partner's passing means your opportunity has expired, you are mistaken. The strategy to switch benefits carries no expiration date, and the framework to demand an error correction is similarly timeless. Both avenues unlock the exact moment you initiate the inquiry, whether you make the call this morning or well into your 80s. The only items on this entire list governed by an unyielding deadline are the brief tasks tied directly to the immediate months following a death. Everything else remains completely accessible, waiting for you to pick up the phone. With that in mind, it is time to examine 3 unpublicized strategic adjustments that possess immense financial leverage, all of which apply with full validity regardless of how long ago your spouse passed away. The first strategic adjustment involves auditing whether the Social Security Fairness Act impacts your financial portfolio. This specific legislation, signed into law in January of 2025, completely dismantled 2 historical regulations known as the Windfall Elimination Provision and the Government Pension Offset. Both of those legacy rules historically slashed or completely wiped out survivor benefits for individuals who also drew a pension from an employer that bypassed the Social Security tax system, a common reality for teachers, firefighters, and police personnel. Prior to the passage of this law, approximately 800,000 widows and widowers saw their rightful survivor payouts completely obliterated by those 2 mandates, not merely trimmed down, but erased to zero. The legislative repeal applies entirely based on your personal work record or the work record of your late partner, completely independent of the year the death occurred, and the financial remedy dates retroactively back to January of 2024. If you or your deceased spouse spent any portion of your career inside a public sector position, contacting the agency directly is vital, as average retroactive payments under this new statute have climbed deep into the thousands of dollars, with certain survivors recovering upwards of $20,000 in back pay that had been withheld. The second strategic adjustment is auditing your late partner's historical earnings statements for structural errors, because your ongoing survivor benefit is computed using their documented lifetime wages, not your own. If even a single calendar year of their employment history is completely absent, or inaccurately low within the master Social Security database, your monthly survivor check is permanently diminished as a direct result, mirroring the administrative trap that caught Linda. You possess the legal right to request these historical files and lodge an official amendment request using Form SSA-78, which is the official request for correction of earnings record, just as your partner could have done during their lifetime. The third strategic adjustment centers on optimizing your federal tax withholding rather than neglecting it entirely or over-withholding out of general anxiety. A high volume of survivors wind up blindsided every April because they failed to withhold a single dollar, while an equal number instruct the agency to withhold massive chunks of their money all year long just to be safe, effectively granting the federal government an interest-free loan of their own capital until tax season arrives. The remedy is identical for both scenarios. Evaluate your genuine combined income against the specific thresholds highlighted earlier and calibrate your withholding parameters to align precisely with your true projected tax liability rather than sacrificing an extra dollar. To turn this information into an actionable plan, the required steps can be divided into two distinct operational paths. If your bereavement occurred recently, within the past 12 months or so, focus on these three immediate tasks. First, contact the Social Security Administration prior to alerting your banking institution and secure a formal confirmation tracking number for the death report before taking any subsequent actions. Second, do not utilize any automated deposits that arrive in the account following the date of passing until you have verified with an agency representative whether those specific funds are subject to reclamation. Third, if the death occurred less than 2 years ago, call the agency specifically to request the $255 lump sum death benefit if it went unclaimed. Conversely, here is the operational path that applies globally, regardless of how much time has passed, whether it has been a single year or 30 years. Contact the Social Security Administration and explicitly direct them to generate a comprehensive written comparison, analyzing both your personal retirement benefit projections and your survivor benefit amounts at every single age milestone from your current age all the way through age 70. Inquire directly whether you are currently eligible to submit a restricted application and demand written validation confirming exactly which benefit track is currently generating your monthly checks and whether a transition strategy remains open to you. Ask directly whether the provisions of the Social Security Fairness Act entitle you to retroactive back pay based on public sector employment histories tied to either your career or your late partner's career. File a formal request to inspect your deceased spouse's lifetime earnings record to verify there are no missing or improperly logged calendar years. Finally, log on to your personal digital Social Security account and take a close look at the exact dollar amount landing in your account today. If that number fails to align perfectly with what a comprehensive comparative analysis indicates you should be receiving, that discrepancy justifies an immediate call to the agency. It makes no difference whether your partner passed away last spring or during a presidential administration from 3 terms ago. Walter made that exact phone call following his casual conversation at the coffee shop. The claims representative completed a thorough comparison, verified that his personal retirement benefit, enhanced by 10 full years of untouched delayed credits, would yield several $100s more each month than the survivor benefit he had been drawing since age 61, and processed the transition immediately. He cannot claw back the financial differences from the prior 10 years. Those funds are permanently gone, and it is crucial to be entirely honest about that reality rather than fabricating false expectations. Moving forward, however, Walter's monthly checks are properly maximized. Linda's scenario concluded with a different twist because her dilemma stemmed from an administrative processing blunder rather than an unexecuted filing strategy, and federal regulations regarding institutional errors absolutely permit retroactive compensation, which is why her investigation yielded both an elevated monthly check moving forward and a substantial lump sum payment covering the years she had been underpaid. 2 distinct errors led to 2 distinct resolutions, yet both rest upon the exact same underlying truth. A resolution is only triggered when an individual takes initiative, dials the phone, and asks the correct strategic questions. If you retain just one single insight from this entire breakdown, let it be this: administrative mistakes do not expire, but delaying the correction costs you hard cash every single month you hesitate. Whether you are a widow or a widower, and whether your loss occurred 3 weeks ago or 30 years ago, the only mechanism that triggers a correction is a phone call you initiate yourself, because no one at the Social Security Administration is going to proactively call you to fix it. If you know someone who has lost a spouse, regardless of whether it happened last week or 20 years ago, pass this information along to them if they have never directly asked the agency to audit their benefit track. That single action could be the exact catalyst that restores hundreds of dollars to their monthly budget for the rest of their days. Drop a comment if this is a situation you have been dealing with yourself. It is important to remember you are not alone in navigating this journey.